If you're involved in selling a home tied to probate, trust, and conservatorships, and there are multiple heirs or beneficiaries, you're not just managing property. You're managing people, emotions, expectations, and sometimes serious conflict. It's not always easy, but it doesn't have to turn into a nightmare. In this video, I'll walk you through the 5 most common disputes that come up with families that are selling inherited real estate, and more importantly, how to resolve them before they derail the sale or land anyone in legal trouble. Whether you're a fiduciary, executor, trustee, or a family member just trying to keep the peace, this is the guidance you didn't know you needed. If we haven't met, hi, I'm Andrew Vries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions, and this channel is here to help you avoid costly mistakes. If this information is relevant to you, please consider subscribing below. So let's jump in. The first big conflict, heirs fighting over what to do with all the stuff inside the house. Personal property can be one of the biggest time sucks and emotional minefields in any probate or trust sale. Who gets what? What's something worth? And what's just sentimental? How do you determine value of these items? And more importantly, how do you get everyone to agree on it? This can delay a sale for weeks or even months. That's why it's so important to develop a plan early. Start with the will or trust. What does it say in these documents? Who gets what? And if it doesn't clarify that, work with the heirs to create a system for distribution or liquidation. And if there's no money in the estate for clean-out services, then what happens? That changes your options and timeline. The bottom line, don't underestimate personal property. Get clarity on this piece early, as it can be one of the largest time sucks involved in estate and trust properties, and it could hold everything up. Dispute number 2, a family member who won't leave. Say you have an adult child, sibling, or grandchild who won't or can't leave their house. Perhaps they've never lived anywhere else. This can get emotionally and legally complicated fast. The family wants their inheritance. The sibling who's living there may feel entitled, or they may just have nowhere else to go, and other heirs might resent them or refuse to help. Before anything else, ask these key questions. What's the current financial situation? What authority does the executor or trustee actually have? Are you in a city like San Francisco, Berkeley, or Oakland where tenant protections make eviction extremely difficult? Sometimes you can sell a home with the occupant still living there, but that might reduce the buyer pool or lower the cost. Other times you may need legal help to remove them. It's critical to assess this situation up front, because if you don't, it can turn into a legal mess that stalls the entire estate. Dispute number 3, one heir wants to buy and the others don't agree. One heir wants to buy the property, but others either don't want to sell or want to buy it too. This gets tricky really fast. First, check the will or trust. Does it require the property to be sold? Does it allow an heir to purchase it? Then consider these key questions. Can that heir actually afford to buy the home? How will you determine the fair market value? Will all the other heirs agree on the terms? This is where legal safeguards matter. Attorneys will recommend things like using a notice of proposed action to all the heirs. You may then seek signed consents for those notice of proposed actions. You may also ask the court for instructions, or in extreme cases, you may want the sale to be court confirmed if and when it's required. These protect the fiduciary from liability and help make sure all heirs feel the process is fair. Dispute number 4. Disagreement over property preparation. Say the administrator wants to prep the property one way and the rest of the heirs don't agree. One wants a full remodel and the other wants to sell it as is, maybe even with all the personal property still in place. Some want to evict the tenants, others say, let's leave them and sell around them. At the heart of this is fear. Heirs may not trust that the administrator or trustee is acting in their best interest to get the highest sales price. So what do? You create a clear and transparent plan. Show the costs, show the benefits, lay out the timeline and the expected return on investment, and keep everyone in the loop. Should you do a lipstick renovation or a full remodel? Should you sell with or without tenants or occupants? Each choice has pros, cons, and consequences, but communication and documentation are the best tools for staying on the same page. Dispute number 5, disagreement over the price and sales process itself. Finally, you get to the sale and everyone is fighting over how the property is listed and sold. This is one of the most common issues, and it's usually again rooted in fear or mistrust of the person in charge. One heir thinks the price is too low. Another thinks it's too high. Someone wants to use their friend as an agent. Someone doesn't like the marketing plan. To avoid this, you need clear, documented strategy from the start. This means a formal valuation to determine list price, an understanding of how list prices and sales prices differ in the Bay Area, a qualified real estate broker everyone understands is neutral, and a marketing plan that's shared up front. In addition, that broker should provide regular updates so no one feels left in the dark, and full transparency at the point of offers. If it's a court-confirmed sale, even better, because the process is public and structured. So let's recap. Number 1, personal property can cause huge delays and emotional conflict. Don't ignore it. Plan for it early. Number 2, family members or tenants in the home can make selling difficult. Triage that situation before you take the case or make any promises. Number 3, heirs who want to buy the property may create friction. Address those conversations up front to avoid headaches later. Number 4, disagreements over property prep can cost time and money. Present clear justifications for your plan and communicate often. Number 5, disputes over the sales process can turn a simple transaction into a long, frustrating ordeal. Transparency is your friend, and so is a strategic shared plan. Now that you've got a better handle on how to avoid family disputes in trust and probate real estate sales, you might be wondering about how these same sales differ from standard real estate sales. In this video right here, I walk you through how probate and trust sales come with unique legal requirements, court oversight, and additional complexities that most agents just don't have experience with. And that can cost you a lot of time and money. So watch this video and I'll see you over there.